get kicked off, I want to say welcome and good morning. My name is Steve Stumbers. I direct Bucknell University's Small Business Development Center. Thank you so much for joining us today. And please know that we want to make it super easy for you to follow up with the SBDC. Whether you're here in Central Pennsylvania, connect with us at Bucknell University Center, or anywhere that you are located throughout the state of Pennsylvania. There is a Small Business Development Center hosted at a university near you that provides services to the county that you live in or that your business operates in. Know that the Pennsylvania SBDC network is a resource for you for educational programs like this webinar today, and for one-on-one consulting, helping individuals start businesses and helping small business owners to tackle the challenges that they face in their day-to-day operations, and with topics like today's, to innovate, to create new opportunities for your business and to grow and to be prosperous. So thanks again for joining the SBDC. I'd like to introduce my colleague, Ian Proud, who is the Innovation Manager for the Bucknell SBDC, serving businesses in Central Pennsylvania and beyond. So Ian, welcome, and good to see you on Zoom.
Thanks, Steve. Welcome, everyone, to this morning's review of Intellectual Property 101 from the U.S. Patent Office. We have with us Albert Wong, who's been a patent examiner for 28 years and worked with small business extensively. Let's welcome Albert. And if you, Albert, would like to mention anything more about your background and more detail, please do so. Welcome, Albert.
Welcome. Good morning. I guess we'll get started. This presentation is intended to be kind of an overview on intellectual property. I think there will be a sister presentation focusing specifically on patents.
Yes, we're going to do that one on July 20th, the one that is just patents.
Okay. First, a word from our legal department that the products and trademarks that you'll see are for educational purposes only and do not constitute an endorsement by the government. We'll be talking about IP as a business strategy. What is intellectual property, the various forms of intellectual property, and some resources that can be found at the United States Patent and Trademark Office. So if you're interested in how intellectual property can help you in your business, this is the place. Why is IP important as a business strategy? Well, it's attractive to investors and buyers. The more intellectual property you have, the more value your business has. It can add value in terms of your company's assets, and it can increase your leveraging and power in case your company is merged or acquired. First of all, what is intellectual property? Well, we're all familiar with real property, which is tangible things. But when an artist or an inventor creates something, he has created real property. So when a painter paints something, that painting can be bought or sold just like a house. But what he's also created is a concept. And that concept is what we call intellectual property. Why is that important? Because with intellectual property, it can be copied and shared. And therefore, you can create what we call an ongoing revenue stream. So instead of just selling one item, you can sell the item multiple times, and with each sale, you can make a profit. So think about a recording artist. Each time he sells you a record, he's selling you intellectual property. If you're an author of a book, you can sell the book, but you can also sell the rights of the book to a publisher. And the publisher can make multiple copies of that book and sell it to the public. With real property, it's easy to protect. You can lock it up in a safe. You can, deny people access to it. With intellectual property, the issue is the fact that once that concept is out there, people can recreate it. So the issue is, how do you protect that? Well, the Patent and Trademark Office, we protect inventions and we protect trademarks. And so first of all, I'd like to use a bit of terminology. We grant patents, but we register trademarks. Some basic information: we have about 13,000 employees. Out of those, about 8,000 are patent examiners. Last year, we had about 650,000 patent applications, and a little over half were granted as patents. On the trademark side, we had about almost 1 million trademarks, and that's growing each year. And a little less than all trademarks registrations were, the trademark applications were registered with the office. The foundation of intellectual property can be found in our Constitution. The Constitution gives Congress the power to promote the progress of science and the useful arts by securing for limited time to authors and inventors the exclusive right to their respective writings and discoveries. So because this is a right that's created by Congress, is subject to change. And there's certain limitations that are going to be placed on the rights, including duration, what is required to get these rights, and whether a right should be granted to a particular class of invention or creation. These are the 4 common types of intellectual property. Most people have heard of patents, which protect inventive ideas. There are trademarks, which identify the origin of goods and services. There's copyrights to protect creative expression. And there are trade secrets, which is any information that's valuable and kept confidential. I'll go into each one of these and show how they would relate to a corporation. A corporation can have one or more of these rights. If you look around yourself, you'll find intellectual property exists just about anywhere. For example, if you take a look at your cellular phone, it might have a trademark, which is the manufacturer of the phone or the software of the operating system. It might be covered by numerous patents, which might anywhere from the battery to the display technology. The software is protected by copyrights, as well as things like instruction manuals or ringtones. And there are various trade secrets that are embedded within the phone. Even the design of the phone, the size, shape of the phone, as well as how the display screen may be protected. So let's start with the first form of intellectual property, which we call trade secrets. These are 2 common examples of trade secrets: the formula for Kentucky Fried Chicken and the search algorithm for Google. So what is a trade secret? A trade secret is any commercially valuable proprietary information. It's a very broad category. It can cover anything from an email list to formulas, and it's anything that gives you an advantage that's not commonly known to the public. Its protection comes from the fact that it is kept secret. There's nothing you need to do. There's nothing you need to file. As long as you keep it secret, you have protection. The downside is that if that secret is revealed in any way, whether it's theft, reverse engineering, independent development, that protection is lost. So it's important when you're protecting a trade secret to take steps to keep whatever information safe. So you might have non-disclosure agreements with your employees, or the formula may be locked in the safe and only a very select few people would actually know the actual formulation. Another form of intellectual property protection is copyrights. And this protects the works of authors of original works of authorship. And it includes things like literary works, dramatic, musicals, artistic, and other intellectual property works. Music and books are probably the most common forms of copyright, but it can encompass a really large body of things. Almost anything that's created, that's put into tangible form, can be subject to copyright protection. So what is the requirement? Well, the work must be fixed in a tangible form of expression. So it's got to be more than something in your mind. So it must be recorded in some sort of medium. It could be paper, it could be something like magnetic tape, but it needs to be fixed. It doesn't need to be something that is perceptible to the user. So if you're looking at something like a recording or a music file, it's considered fixed, but you might require the aid of a machine or device to actually view it. So what types of works are protected by copyright? Well, first of all, it must be an original work of authorship. That means that it's been created independently by the author and not merely copied. The US requires what we call a modicum of creativity. So it's got to have some creative aspect of it. It doesn't have to be much, but it has to be sufficient to be considered unique. So these are some of the categories of protected works: literary works like books and magazines, musical works like songs, sound recordings, dramatic works like a play, choreographed works, motion pictures are another category of copyright protection, and even architectural works. So a design of a house, the blueprints could be subject to copyright protection. What about things like compilations or derivative works, which means it might include things that are existing and things that are new. As long as it's fixed in a tangible form of expression, it can be protected. So it doesn't necessarily have to be 100% original. It can have like a collage, a combination of existing works can be protected through a copyright. What is not protected is works that have not been fixed, titles, names, symbols or designs, ideas, procedures, and concepts, and works that are entirely of common ownership. That means that the author has really not created anything new. What is the term of protection? For works created on or after January 1st, 1978, it is the life of the author plus 70 years. For creations that are created by a person. If it's something that's considered a creation by a corporation, it's 95 years from the time of publication. So what's an example of something that is created by a corporation, something like a movie where you have a lot of individual people together, but the creation is a combination of the efforts of each person. So what does this right entail? It's a right to reproduce the work. That means you can make copies of it. The right to make derivative works, so you can alter whatever it is. It includes the right to distribute copies. You can perform the work publicly. You can display the work publicly. So let's say you're broadcasting something like a football game, or if you go to a movie theater and they're showing a movie. These are all copyrighted products that the owner has taken advantage of the rights associated with it. And it could you can authorize other people to make use of these rights if you're the copyright owner. A copyright is created at the time of creation. But what you can also do is you can register whatever that creation is. And it gives you a lot of significant benefits. The first benefit is that you can file a suit in the federal court. And that gives you a means to enforce the copyright protection. It's also evidence of the validity of the copyright. So if someone comes to you and says, well, this is my work, if you have a registered copyright, you basically have evidence that you are the creator of this work. It also gives you protection by the U.S. Customs and Border Protection. So if someone tries to import this work, you can have the government seize these properties. But probably one of the most important advantages of a registered copyright is that you can recover much greater statutory damages and attorney fees, and often that will be a very strong deterrent for someone that is thinking about copying your works. And certainly it makes it much easier to license out your work and collect royalties. The third form of intellectual property is trademarks. And I think we're probably pretty familiar with examples of trademarks. These are some examples. A trademark can be a word, a name, a symbol, or a combination, and they're used to identify and distinguish goods and services and to indicate their source. And frequently that's denoted by the word TM or SM, TM for trademarks, SM for service marks, and usually the way you denote it is the R in a circle. So what do trademarks offer? Well, they offer brand recognition. So if there's many manufacturers of a good, it shows the origin of the good, and frequently is used to denote a superior good. So instead of something that's generic, that can be manufactured by any number of different manufacturers, it is specific to a particular manufacturer, and generally often is a sign of quality. So think about something like Coca-Cola versus a generic cola beverage. A trademark is a public notice of the ownership, and it gives you the right to enforce your right nationally and bring action in the federal courts. And just like with copyrights, you can make use of government protection through the Customs and Border Protections. It can also serve as the basis of a foreign filing. And a registered trademark is published in the US Trademark database, so other people can look it up and determine who the ownership of this of a trademark is. So what is the definition of a trademark? It is any word, slogan, symbol, design, or combination of these that identifies the source of goods and services. So, well, most of us are familiar with trademarks as a source of goods, something like a McDonald's hamburger, but a trademark can also cover services. And most of the time you'll find that in something like banking and credit cards. So these are kind of services that are protected by trademarks. So you can imagine something like American Express and their trademark. They have a service mark protecting their brand of credit cards. And it is used to distinguish your goods and services from those of another party. So these are examples of trademarks. It can be a word like the word Coca-Cola. It can be a design like the polar bear, or it can be a combination of both, which is word as well as designs as shown in this composite mark. So it's not uncommon for a company to actually have more than one trademark associated with a product. These are other examples of trademarks. You can see how they can be pretty wide ranging. The shape of the Coca-Cola bottle is trademarked. The display screen on a cellular phone. In terms of shoes, the red soles of a Christian Louboutin shoe is protected by a trademark. The turquoise fox for Tiffany jewelry, the shape of the Hershey's Kiss with the tassel, and even the color, Owning's Corning fiberglass insulation. The pink in the Pink Panther is protected by a trademark. Oftentimes, when we talk about trademarks, we talk about strong and weak marks. So strong marks is generally desired over weak marks because they give greater forms of protection. Something that's fanciful and arbitrary is usually considered the strongest mark. Something that's suggestive, a little less so. If something is merely descriptive, you can still have some trademark protection. But if it falls to a part where it's generic, then that's something that cannot be protected by a trademark. So these are kind of examples of different types of marks. The strongest mark are the fanciful ones like Microsoft and Cisco. And when you think about it, once you see the mark, you know that what comes to mind is an association with a particular company and a particular brand of item. Something that is a little bit more arbitrary is still protected by a trademark, like the word Apple or Gap. Even something that is suggestive, so it's, in this case, it's words that are descriptive, like Coppertone and Dryfoot, are still protected by trademarks, although the protection may be a little less given the fact that the association with the words is not as strong with the product as compared to the more fanciful marks like Xerox. So these are examples of weaker marks, words, things that are just merely descriptive. Something like apple pie for potpourri. And the lowest example is the generic. Generally, the generic words are not subject to trademark protection. So if we're thinking about something like milk for dairy products, generally they are not considered available for trademark protection. So why register a trademark rather than just use a trademark? First of all, you get nationwide protection. The other thing is that you put other people on notice. So people that may think about using a similar mark or the same mark, it puts people on notice that you have considered that your property and you are willing to enforce that right. The other advantage of registering a trademark is it prevents other people from registering marks that are very similar like yours. The United States Patent and Trademark Office will not register an application where the mark is considered confusingly similar to an existing mark. That's where there's usually going to be a little bit of judgment involved. A registered trademark allows you to use the R in a circle, and that is kind of evidence to other people that this is something that's protected as a trademark and is not freely available to others to use. A registered trademark also allows you to prevent the importation of infringing goods. It can also be used as a basis for registering the trademark in a different country. So just because a trademark is registered in the United States does not necessarily give you rights outside the United States. However, a lot of times it makes it a lot easier to register a trademark in another country. And you can have increased statutory damages and attorney fees, which is just like copyrights. It's a great deterrent for other people that might think about using your trademark illegally. So finally, we're going to touch on the last form of intellectual property protection. It's probably the most important, and it is also kind of the most complicated, which are patents. What is a patent? Well, it's a right to exclude others from making, using, selling, and offering for sale, or even importation, the claimed invention. It is of limited term, and it's limited to the United States. If you seek patent protection in other countries, you're going to have to apply for them individually. Generally, there are 3 types of patents. The most common are utility patents, and they generally protect something that's useful. It can be in the form of a process, a machine, an article of manufacture, or a composition of matter. The second form of patent protection is what we call a design patent. It protects the way a product and article looks. So you can imagine something like a case, the shape of a Coca-Cola bottle, or even the display screen on your phone. The way the phone looks when you have the home screen has been protected through design patents, and even plants can be protected. Newly invented strains of asexually produced flowering plants and fruits and hybrid plants can also be protected. What's meant by asexual reproduction? It means that it's not reproduced by seeds. And the reason for that is that plants that are reproduced by seeds generally don't, the traits associated are not very reliable. So the one of the questions in terms of patent protection is if an idea is eligible for protection? Well, first of all, an idea in general is not protected by a patent. It is an invention. So the difference between an idea and an invention is generally what we call how concrete it is. So you can think about something like an idea is more like something creating light from electricity, whereas invention is more like a light bulb where the structure and details are known. What are the requirements for patentability? Well, first of all, your invention must be novel. It means that just means that it must be new. It hasn't existed before in the history. But there's also a second requirement, what we call non-obvious. This is kind of a difficult concept to understand. So something that can be new may still be considered obvious and would not be subject to patent protection. So what does it mean to be non-obvious? Well, within every field, there's kind of a pool of knowledge that people can use to create different things, and these that pool of knowledge allows you to do minor differences, and these minor differences are considered obvious and not eligible for patent protection. So in order for something to be patentable, you have to go be above a certain bar, a certain threshold in terms of inventiveness. And finally, it has to have some sort of utility. And when I'm talking about these 3 requirements, they relate to utility patent and not the other 2. What is not patentable? Merely an idea. So you just have a broad kind of concept, but you haven't figured out how to make and use the item. That cannot in itself be patentable. In order for something to be patentable, it has to fall under one of these 4 categories of machine, manufacture, process, or composition of matter. Other areas that are prohibited from getting a patent is something like natural phenomena. So if you think about if you discover something like the law of gravity, or if you're Einstein and you figure out E = mc², these are considered natural phenomena and not subject to patents. However, inventions that are based on phenomena can be patented. Another category of things that cannot be patented are what we call abstract ideas. So what is the path to a patent? Well, you start out with a new idea, and you have to make a filing with the patent office. And there are 2 possibilities of filing. The first is what we call a provisional application. This is optional. Or you can file what is called a non-provisional application. The provisional application has got a lot of advantages, but it doesn't mature into a patent. What it does is it gives you a 1-year timeline to hold your place in line. The way patents work is that the first person to file an application gets a patent. If you're number 2, you get nothing. So it's important that you have the first application. But oftentimes, you may not be ready to file an application, or because it's quite expensive and generally you have to employ an attorney. What you can do is you can file a provisional application which kind of holds your place in line. And within that year, you can file the non-provisional application that will be examined by a patent examiner like myself. And if it fulfills the requirements of utility, novelty, as well as non-obviousness, it gets issued as a patent. So what is the difference between a provisional and a non-provisional application? Well, for the provisional, it's not examined or published. It only lasts for 1 year. It's only for utility patents. And it really is a simple and cost-effective way of establishing an effective filing date, which is merely establishing your place in line. The other advantage of a provisional is that once you've filed it with the Patent and Trademark Office, you can stamp patent pending on whatever product you're making. The non-provisional, however, is something that is examined. It's generally published 18 months from the earliest filing date. However, in certain instances, you can request non-publication, and it can become a patent if it fulfills the requirement. So, so when you're beginning, if you're not quite ready to jump all in, you can do the provisional and then follow that up with the non-provisional within 1 year. Or if you're really ready to file your patent application, you can jump straight to the provisional, the non-provisional. So the provisional application is not a requirement. So how does the process work? Well, you file the application. In this case, it would be the non-provisional application, and the examiner, like myself, will review it for requirements. And if it doesn't meet all the requirements, you're going to get something called an office action, which will list what we call rejections or objections. And that's just a way of saying that you have some deficiencies in your application. So you have not fulfilled all the requirements of patentability. And you will have an opportunity to make some amendments and arguments. So you might make some changes in terms of your claims, and you might make some arguments to the examiner saying that, oh, you know, you didn't quite understand my invention. This is how it really works, and I think I still deserve a patent from it. Now, this process can go back and forth, so it's not just necessarily one and done. And it generally ends with either you're able to convince the patent examiner, which means that you're granted a patent. If you are unable to convince the examiner and you just give up on your application, it's called abandonment. You don't have to do anything besides just not respond to the correspondence of the office. If you disagree with the examiner, there's an appeal route. So there's a body, there's a board that will review applications where you and the patent examiner have a disagreement. And based on the determination of the board, your application may grant as a patent, or it may be determined that it's not patentable. These are some of the resources that are available from the U.S. Patent and Trademark Office. You can find this on our website, www.uspto.gov. The Patent Office is divided up into 5 geographical zones. The headquarters is located in Alexandria, Virginia, but we also have a regional office in Detroit, Denver, Silicon Valley, and Dallas. There'll be people that you can consult in the various offices that can give you some sort of guidance. There are some resources that are particular to headquarters that can be found on our resources page. We also have a video library that is constantly being added to that may have some very useful information. Another resource is our subscription center. This is during the year, we often do various presentations that are virtual, and this pertains to both patents as well as trademarks. And our courses are free, so all you have to do is kind of sign up for them. And if you sign up with our subscription center, you'll generally get an alert when new courses or new presentations are coming up. We also have an events webpage, so you can take a look at some of our courses that you might think that you might want to sign up for additional information. We also have a page for various resources that are available. So it'll talk about the trademark process as well as the patent process. There's some resources for starting a business as well as some current events. And it kind of is a general guide in terms of interacting with the office. This is a very important resource. It's what we call the Inventor Assistance Center. This is a number where you can call to speak with an examiner like myself, who can answer general questions on patent examination policy and procedure. What they cannot give you is legal advice. And not to leave out the trademark people, there's also a Trademark Assistance Center, which can give you some guidance as to the filing of a trademark. We also work with some attorneys in what we call the Patent Pro Bono program. This is something that attorneys have volunteered their time to help independent inventors through the filing of a patent application. There are some pretty strict guidelines. The first and most important being that your income must be less than 300% of the federal poverty guidelines. You're still responsible for paying the filing fees and the costs. Generally, what's required is you watch a video to be familiar with the patent system. Not every application except a file with the pro bono program is accepted because there generally is a limited amount of attorney resources. The pro bono program covers all 50 states. In general, there might not be an attorney for each and every state, so sometimes you have to travel to find an available attorney. In addition to the pro bono program, some of the law schools have created clinics which also can help with patent filings as well as trademarks and answer various questions. In general, the law school programs have much less strict income requirements. So if you don't qualify for the patent pro bono program, you may qualify for one of these law school clinics in your area. In addition to the other two resources, there are patent and trademark resource centers scattered throughout the United States. And these are local libraries that are dedicated to providing information on patents and trademarks. So they can guide you in terms of doing a patent search, as well as provide you with some basic information regarding filing patents and trademarks. These are other PTO resources and the various links. I think copies of this slide deck will be made available, so you don't necessarily have to write these things down. And that's kind of concludes our presentation.
Thank you, Albert. There are a couple of questions in the chat that I'd like to present to you.
Okay.
The question around the 75 years or after the person dies, is there any possibility of transfer of that copyright to a family member?
Oh, absolutely. Your copyright, it's like any other right. You can sell it and you can transfer it through your will. So instead of maybe leaving your house in a big bank account to your heirs, your copyright protection can be given also to a family member, or even, it doesn't even have to be limited to a family member, a friend, a organization, or whatever.
And another question is that around the idea of publicizing a song or publishing a book, is copyright still required if it's been published by the author?
Well, the copyright protection comes to life the minute you create it. So when we're talking about the protection, it's the registering of that copyright that gives you additional protection. One of the examples is it gives you access to the federal courts. So you can sue people, and you can use the government to enforce that copyright protection so that people can import the works from like a foreign country or something of that nature.
Okay. And the question about the slides, Albert, is will you make those available to us and we can distribute them to the attendees?
Yes.
Is that going to be okay?
Yeah, that will be okay. We'll give you a protective slide deck, and you can make that available to your attendees.
Great, thank you. Are there any other questions that Steve or Shelley you see on the chat?
I wanted to share the place to find the slides from Albert and I'll put this link in the chat as well for everyone, in the email that you received from the Bucknell SBDC when you registered for today's event. We referred to an e-center, our electronic center. So log into that. You'll find that link in that email and in the chat shortly. Find this event and any materials associated with it, i.e. Albert's info packed slide deck. You can download that. So as he said, all of those links You can follow up with those easily in case you didn't grab them from his presentation on screen today, or the few of them that I added to the chat about videos available from USPTO, their learning resources library, that will all be available to you in the SBDC's eCenter.
Yeah, I guess I'd like to kind of give an example of how the various forms of intellectual property can relate to a business. So let's say you have a pizza restaurant, right? So your name, Ray's Pizza, can be the subject of a trademark. Your menu can be subject to a copyright. And your secret supplier of cheese may be something that's considered trade secret protection. And but let's say you're a very prolific inventor, and you found a way to make a better pizza oven. So that invention can be subject to a patent. So this is kind of an example of a business with all four forms of intellectual property protection. It's not necessary to have all four. Sometimes it's not necessary even to have any one of them, except for maybe the trade secret type stuff. The other issue that wasn't brought up is in terms of trademarks, is that the trademark protection is usually limited to a category of goods. So it's not uncommon for a trademark to be owned by two separate companies as long as their goods are different enough. The one that comes to mind is the word Beretta. It stands for an Italian gun manufacturer, but General Motors also had a car called Beretta, but no one would really confuse a gun manufacturer from a car manufacturer. So even though the word is similar and it's been trademarked in two different categories, that is also valid. So oftentimes when you register your trademark, they'll ask you which category of good you're trying to protect, and you can list more than one category.
Are there any further questions or comments from anybody?
Albert, you referred to intellectual property and the pizza industry. One piece of news that got a bit of attention recently is a pizza robot that is developed by some former rocket scientists and engineers from SpaceX. Mm-hmm. And they just announced a pretty large entry into the market with some serious investors that they picked up. No doubt a lot of intellectual property. Actually, so I guess a question there, what types of intellectual property would you imagine are involved in that type of business enterprise?
Well, certainly, the design of that robot can be covered by patent protection, particularly, if that robot is new and useful. It works better than other robots. Maybe it's, particularly designed for pizza making. But the company, if it's selling the robots, might actually have a trademark to protect their brand. And so that's another kind of form of protection. The manual for operating that robot is protected through copyrights. And certainly, you might actually have even some trade secret protection that's possible. Mm-hmm. I see that there's a question of if a friend created a logo for you, do you need permission to trademark it? Well, it depends on the nature of your relationship. So this kind of falls into a legal advice type stuff. If you hire somebody to create a logo for you, generally you're the owner of that logo, and so you paid them to create it, and therefore you have the right to trademark it.
a follow-up note about that logo, I believe, in the chat.
Mm.
Expanding upon your note, it was the logo, I believe, was created by Canva or using the graphic design, the online graphic design tool or software, Canva.
Yeah, well, you can use products to help you in the design process, but as long as you're the creator of the mark, then you can register the mark. In general, in the United States, we require you to use a mark. So in other words, it's not just a placeholder. It is, you have to demonstrate that you are actually using the mark. It could be in form of a letterhead, advertising of that nature. It's not a strict requirement that that the use be at the time of filing, but generally, if you haven't demonstrated the use, the Patent and Trademark Office will come back after a year and say, well, do you have some evidence of use? Otherwise, we're just going to cancel your registration if you don't have a use for it.
And I imagine that the question also revolves around who created that like work of art, that graphic design, versus where it's being applied, the business using it on its products. Could you expand on that?
Yeah, I mean, yeah, you don't, with the trademark, it's associated with a good or service. So it's less, unlike the other forms of intellectual property protection, which are focused in on the creator. With the trademark, it's the person using that mark and what good and service is associated with it.
I think that's thank you for that response. So associated with the good or service provided by that business, and that is the one who has the permission or the rights to use that trademark in their operations.
Yeah, in general, the more you use a mark, the more valuable it is, because its value comes from being in the mind of the user. When people see a mark and they instantaneously associate that with the good, that's where you get a very strong mark. However, a lot of times marks can be very, very successful, and with the passage of time, it becomes kind of what we call genericized. When we talk about, oh, well, give me a Xerox copy. We're not necessarily thinking about a product that comes from Xerox, but just more like a photocopy. And it's important not to let your mark get genericized by, just people using it as a kind of colloquial term, because you can lose some protection if your mark does become generic. One example I can give you is Band-Aid. All right, it's a Johnson & Johnson product, and they used to have this little jingle that I want Bandage brand bandage. So in other words, it's a brand and not just a generic word for anything that is a bandage.
Knowing that we have a relatively small number of people here, let me invite people, if you have any further questions, either, of course, as usual, put them in the chat, but go ahead and open up the floor to questions from anyone who wants to ask them aloud. Feel free to unmute yourselves and jump into the conversation. Definitely welcome you to do so now.
Hi, my name is Regina, and I asked a question about when you have a song or you write something, and I heard, like, once you write it and say it's on social media or something, it's already copyright, or you still have to have that extra protection. That's what I'm kind of confused with when you was answering that question.
Oh, sure. You're absolutely
Thank
correct.
you.
Yeah, when you put it on social media, at the moment it's fixed, and in terms of it's put into a tangible form. So if it's put onto a web page, it's been created. You have what is called the basic protection in terms of copyrights. Now, by registering your copyright, you get a lot of additional protections. So it's not, it's not necessary, but it's advantageous to register your copyright. But at the moment of creation, the minute you write that song or the minute you do that performance and you record it, you have protection.
And is the protection just for the United States when we do the copyright? I don't know if you said that, or is it for like outside of the United States? And is there an expiration date on trademarks and copyrights?
Oh, sure. All these forms of intellectual property protection is limited to the United States. So if you require protection outside the United States, you're going to have to file with the various different countries and fulfill their requirements. Now, what was the second part of that question?
For the trademark, because you mentioned like Band-Aid, that was a good, I'm happy you mentioned that. Is there an expiration date on the trademark? Do you have to keep renewing it, or if it become like general, like people, like say Band-Aid, they look at everything as a Band-Aid, but that is actually a brand.
Yeah.
So is there an expiration date on the trademark?
Well, theoretically, a trademark could last forever. Generally, after the first 5 years, you have to kind of, continue the mark, and then every 10 years, there's kind of a renewal process. So there's a little bit of money paid to renew that trademark, and it can go on for as long as you're making or using a product that's associated with it.
Oh, okay. So that means like if you're not, say if you have a company and you have a trademark, if you're not using that, you monitor it. If it's not being in use, then it get taken away. So it's like a renewal date, a renewal every 10 years or so.
Right, right.
Thank you so much.
Yeah.
Good questions. Thanks for jumping in. Anyone else have questions as well?
Sometimes you need to take some steps to prevent your trademark to become generic. For example, the example that comes to mind is Coca-Cola. I'm sure some of you have experienced the situation where you go to a restaurant and you ask for a Coke and they come and say, well, is Pepsi okay? And that's the reason why they ask, is that they don't want the word Coca-Cola to stand for any cola beverage. And so, so if a restaurant is offering you a different product like Pepsi, they want to, to make sure that their product is not being or the word Coke is not being associated with a different product and different manufacturer.
I have one more.
Go ahead.
This one is, someone told me, and I don't know if this is true, you can put a little circle by your name, but it's not registered, but that lets people locally know that that is a trademark. The C circle or the copyright, I heard something like that, and I'm not sure if that's true.
Well, copyright, the C in the circle doesn't require you to register the copyright. So it's available to anything. It just puts people on notice that this is a copyrighted work. With trademarks, the R in the circle shows that it's a registered mark. If you choose not to register it, you can just use the word TM or SM, TM for trademark and SM for service mark next to whatever your logo is, or even your name. And that puts people on notice that that this is a trademark. It may not be registered, but it is subject to some sort of trademark protection.
Thank you.
Just to give you an example, you know, oftentimes we don't think a lot about intellectual property protection until something comes up. In New York City, there was a very famous case of Ray's Pizza. It was owned by a family, and the family had a disagreement. So the various people started various members of the family decided that they were going to open up pizza places also. And so they started calling it, you know, by different similar names: Ray's Pizza, the original Ray's Pizza, the famous Ray's Pizza, the famous original Ray's Pizza. So this is an example of what happens when there's not a registered copyright protection. So you have various members fight over the name, which, you know, has quite a bit of value. And now, if you're going, you know, to look for a pizza place, you can't distinguish between Ray's and original Ray's and the famous Ray's, and so that creates an issue if there's not a registered trademark. Oh, there's a question here. Let's see. Yeah, the R in the circle is a example of a registered trademark where TM is just a generic symbol showing that there is someone has considered whatever that mark is to have some sort of trademark protection.
And I think often the confusion is who gets to use the R in the circle and who can use the TM that raised up small letters TM after the name of their good or service. Could you reiterate that? Who has the rights, or who is able to use TM, and who is able to use R in a circle?
Anyone can use TM, you know, but when you register it with the Patent and Trademark Office, once you've been approved to be registered, then you can use the R in the circle. If you want, we actually have a trademark presentation course that kind of mirrors our patents. It's taught by a trademark examiner. So if there's interest in it, that certainly is a course that can be presented also at a later date.
Oh, great.